after Andrew on the video. So it'll be Andrew Lemanski, Marion Tolan, and Clayton Tucker. How you doing, Mr. Lemanski?
Good. Thank you, Chairman White. My name is Andrew Lemanski. I'm a civil rights attorney in Houston, Texas. I'm here on behalf of myself today and by extensions, my clients, including Josh Cookie. And I am for the bill, extremely for the bill. I want to show you what I brought here today. This is the journal, Harvard Journal of Law and Public Policy. I got this when I was the president of Republican law students at South Texas College of Law. And I got this because I helped refound the Federalist Society there, and at the time, they were providing complimentary subscriptions to their chapter presidents. I was sort of considered the founding president, but I didn't want the two groups conflated, so I kind of quickly said, okay, but they gave me this nice book. And you know what it says right here? Law and Human Dignity. I thought it's very fitting for this particular hearing. Chairwoman Thompson, thank you for this bill. I can say that as someone who believes that our rights come directly from God, and they are merely recognized by our Texas and federal Constitution. I want to explain to you what I've seen as a civil rights advocate. And we've heard some talk about qualified immunity. I want to explain to you how it actually works in a jury trial, what I've done. There are two questions. The first is, are your civil rights violated? The second is, does qualified immunity apply? So a jury will always be asked that second question only after the jury finds a civil rights violation. What's crazier about qualified immunity is when you look at 14th Amendment, substantive due process, use of force, things that happen in jail, people that are actually incarcerated, the force used on them. The standard under law is quite literally that you have to intend to harm and have subjective evil intent. Now think about that for a second. That's just defined the constitutional violation under the 14th Amendment. And then you're asked about qualified immunity, whether the officer in good faith committed a subjectively evil act. These laws do not make sense. This is a state cause of action under Texas law where Texans can file in state court. They don't have to worry about filing in federal court or ending up in federal court in front of a federal judge in Washington.
So you're saying this bill has that cause of action?
Yes, sir.
Okay.
A state cause of action. I agree with my friends and colleagues at IJ, and I helped out with the brief on Kylo versus New London, the private taking of property case. It was back in about 2005. But and also, I want to talk about my...
Well, let me do, because I'm looking at the timer here.
Yes.
Give me real quick your point on some of the one or two of the policy points, other policy points in the bill, like duty to intervene.
Duty to intervene is absolutely important because there is a duty to intervene under the federal version of the Civil Rights Bill. And this state law would be the exact same analogy, a duty to intervene. That's important because, and this is the other thing that I don't believe was mentioned by the officers that came up here to testify against it, is that just because a department has a policy to intervene or puts that duty on the officer does not mean they have a duty in law. Courts have routinely said that violations of a policy do not, in and of themselves, constitute a civil rights violation. So the issue with that, the duty to intervene is very important, but it's important. It's statutory law, and there's teeth behind it.
Okay.
The other thing, the overcrowding. Briefly, I've handled a case on overcrowding. These low-level drug offenders that are arrested and put into jails, you can think of that like a recruiting mechanism for MS-13 because it happens. These people don't have experience in jails. They get there, they look for protection of gangs, and then they have to do favors on the other.
And Andrew, thank you so much. Members, thank you.
And I'm willing to engage. I gave my emails. Please, any
thank
questions?
you.
I'm more than happy.
I'm sure you're a very, very vigorous advocate for your folks in court. So we'll go with Marion Tolan. Okay, Marion, good afternoon. Marion, good afternoon.